At DuluxGroup, we provide premium paints, garden care, building products in the residential and commercial markets. We have a number of brands that we manage. A number of them are market-leading brands and some of Australia and New Zealand's most recognised brands. I'm one of the legal counsels here. In connection with that is maintenance of our intellectual property portfolio, which is quite large. At last count, I think it was in excess of 3,000 registrations. So it's complicated and it's detailed. I work closely with DCC on a number of those. In particular, I work closely on the trademark side of things. DuluxGroup places a lot of focus on innovation and investing a lot in our R&D. So intellectual property is one of the most important assets we have. And from a trademark perspective, it is a relatively inexpensive way to obtain a level of protection in your brand and things like that. I mean, the application and registration process is usually relatively inexpensive compared to the benefit of obtaining protection for a trademark. You know, the worst case scenario is you spend a significant amount of energy, time, resources developing a new trademark or a brand and you think this is going to work. You put it into the market only to realise that either someone else is using it or it just can't be protected and it's vulnerable for other people to use. Undertaking comprehensive searches is really critical. It will reduce the risk ultimately if we can understand first if anyone else is using it and removing those infringement risks or limiting those infringement risks. Also just understanding if we can protect the mark. So after we've got the searching out of the way and we're free and clear, if we can, we'll apply to register the mark. And it's important that we register the mark in the classes in which we're going to use it. So for example, paint and paintbrushes are different classes and we may want protection for the mark in those two classes. So it's important to make sure that we're applying in those correct areas and putting it in context and how we want to use the product. For us, protective IP doesn't simply come down to applying for a trademark, registering it and forgetting about it. We would have a look at the new trademark applications in Australia in paints, for example, and having a good snapshot of A, what our competitors are doing, but B, what the market's doing generally. You know, are we seeing trends in a way that our products are being used? Is there something that we can do to better protect our marks? And having a good snapshot of the market provides one of the useful tools to achieve that. So this whole process I work really closely with TCC on. A good relationship with an IP firm is one of partnership. It's understanding our business needs and understanding what our strategies are and things like that, and being able to deliver timely, effective, commercially focused, correct legal advice that will help us make the right decisions.